Welcome to the We Get Privacy podcast. I'm Joe Lazzarati, and I'm joined by my co-host Damon Silver. Damon and I co-lead the Privacy, Data, and Cybersecurity group at Jackson Lewis, and in that role, we receive a variety of questions every day from our clients, all of which boil down to the core question of how do we handle our data safely? In other words, how do we leverage all of the great things data can do for our organizations without running headfirst into a wall of legal risk? And how do we manage that data without unnecessarily hindering our business operations?
On each episode of the podcast, Joe and I talk through a common question that we're getting from our clients. And we talk it through in the same way that we would with our clients, meaning with a focus on the practical. What are the legal risks? What options are available to manage those risks? And what should we be mindful of from an execution perspective? So Joe, our question today is, one of our employees downloaded trade secrets. Should I be worried about a data breach? Yeah, well, a lot to unpack with that one. I think maybe a place to start is, with the question that seems to be implied here of, do the trade secrets themselves trigger any type of breach notification or reporting obligation? If the answer is no, is that the end of the inquiry, or is there more to think about? So what is your way of sort of framing that issue up when a client brings it to you? Because I know it's one we get quite a bit. People are focused on the trade secret issue, and the potential data breach is something that maybe is an issue that has been flagged by someone, but is not the predominant focus.
Yeah, I obviously it's a really difficult time for a client. You put trust in an employee, and you find that maybe they downloaded some information or forwarded it to themselves or something like that, and oftentimes there's some pretty important information that's being shared. But I guess the starting point for me is, just in talking to clients about when it happens, and also thinking about if it happened, is just in terms of language, it probably makes sense to not even refer to a breach at that point, because you might have a breach of the system in the sense that someone got in or someone accessed information that they shouldn't have accessed. But the term breach of system security or breach in all 50 states in certain statutes has a meaning. And if you're using that term, it might later be viewed as you reaching that conclusion that you've had a breach, meaning you have, a situation that requires a notification of some kind. So we like to just say, look, you've had an incident or something other than a breach. And but Damon, then I think you're right. You really have to look at that issue, because at least I tend to find that, and this is still the case, I think a lot of clients that I speak with, they only view breach in the context of personal information like social security numbers being disclosed. And that was the case for a while. But at least in terms of statutory or regulatory requirements, there is an increasing amount of situations where business information could be considered a breach, even as lawyers. There's ethical rules that may get you to that place. There are insurance regulations that may get you to that place. In other words, you have access to information that's not personal information, and you might still have a notification obligation. And then it doesn't stop there, because you might also have contractual obligations that don't limit notification obligations by contract to just personal information. But at the same time, right, in the heat of the moment, you have this issue with trade secret. It's going to hurt the business. We have to focus on that. And so, Damon, maybe that's something to kind of think about, is how do you try to balance those two things? It's kind of like what we see in an incident, right? When we're dealing with a traditional, like a ransomware attack, with the company saying, hey, we got to get the business running. It's about the business, but it's also about, all right, but there's been data affected. What do we do with that? So what kind of strategies do you think are helpful for companies that have that situation to kind of balance the business piece of the theft of the trade secret, and then thinking through, is it a breach for notification purposes?
Yeah, fortunately, I think pursuing those two lines of inquiry are not mutually exclusive. And in lots of ways, you're really paddling in the same direction on both. And sort of a starting point for that is you really do want to understand the scope of what was taken and the scope of what was accessed without authorization, because both from defending your trade secret confidential information perspective, and also from exploring whether there's quote unquote breach perspective, you need to understand the scope, and a lot of times it's broader than expected. Maybe we're aware of one email that got forwarded from the employee's business account to their personal account, or we see one instance where they did an upload of some number of files to their personal Box account. Oftentimes, though, when you look into it, it turns out this has been going on for days or weeks or months, and there are many other instances of stuff being taken. Maybe they synced their entire company email box to their personal email box, or maybe there are a whole bunch of different files that they uploaded at different points in time, or they brought their personal laptop in one day and downloaded directly to the local hard drive a whole bunch of your data. You really want to know that, regardless of whether you're just focused on the trade secret issue or whether you're focused on the potential data breach issue. You want to understand the scope of it. The other thing that I'll often talk through with the client is that we can pursue parallel paths in tandem. We can reach out to the former employee, send the demand letter, gear up to go to court and try and get a temporary injunction if that's necessary, while at the same time making sure that we're preserving forensic evidence, engaging a forensic vendor if we need one, and getting the process started on that investigation. It's very similar to the ransomware analogy you brought up, Joe. Forensics can take a while. And also, if you don't take the right steps right at the front end, you may lose forensic evidence that you can never get back. So you do want to keep your eye on the forensics and broader investigation ball, while at the same time, obviously, your immediate focus is probably going to be on how do we get this data back? How do we stop the former employee from taking this to our competitor? So both of those things can happen in tandem. But if you don't think about the potential data breach issue until later in the process, you may lose out on the opportunity to get evidence that you'll ultimately need. The other thing, and maybe you can speak to this, is I find it can be very helpful if we're in negotiations with the former employee to resolve the theft of trade secrets and potential non-compete, non-solicit type issues, to raise the issue of, can we get a declaration from this person that they deleted all the data they took of ours and that they didn't further disclose it anywhere? Because, and Joe, maybe you can speak to this, if you're able to get that, that can change the trajectory of your assessment of whether you had a reportable breach, a breach that you have to notify people about.
Yeah, that's a great point, Damon. I was thinking of something similar, because oftentimes there's a desire to kind of make the strongest case if you are going for that TRO, or you are trying to take some action to stop the employee from using it, or to send the message that data is important and you want it back or you want it deleted. And so you want to try to make the employee feel like, there's some real harm here. And you might say, you've breached our systems, you've breached our data, and now you've put that data at substantial risk. And then when you turn back to the question of whether you've had a reportable breach, in many states, not all, but in many states, you can avoid notification if you can reach the conclusion that there's not a significant risk of harm to the individuals. Well, if you've kind of advanced these arguments in a way that you're saying or alluding to a potential for a major risk, it might be harder to come back and say, well, the risk was over here, but not over here, right? So you're right. You want to be thinking about these things simultaneously to try to understand what's really going on and what's the position we need to take, and whether there really is risk, and if so, that will drive the decision on the data breach. But you don't want to kind of hurt your position in terms of how you react on the other side with the trade secret theft. So yeah, I think those two things have to be kind of thought through carefully and managed, because you also don't have a lot of time in either situation, right? You on the one hand have some significant business implications, but also you have potential notification obligations. Just maybe, Damon, you can speak to just in terms of discovery, right? One of the things from a data breach perspective is, when did you discover that there was a breach? And that may not be at the point that you learned that the employee was sending emails to themselves. So in terms of timing and going through this process, can you talk a little bit about how that's important from the data breach notification perspective?
Yeah, absolutely. I mean, a lot of data breach notification laws will say you have X days, 30 days, 45 days from the date that you discovered the quote unquote breach to provide notice, to submit your reports to government agencies. And so, yeah, you do want to be careful about boxing yourself in. If you put in that demand letter that, that this former employee took your PII, you're kind of putting out there that as of the date of that letter and probably earlier, you were aware of compromise to your PII, which may not be the case. It may be the case that you do some forensic analysis and there is no PII in there. And even if ultimately there is, you don't really know until you look into it further. So I usually will avoid I certainly will avoid saying there's PII in the data set, but I don't even go into the specifics of what type of information I think it might be. I will flag certainly the fact that we are aware of you exporting our data or forwarding emails to yourself on these dates or on multiple occasions, but I won't commit the client to what specific type of data it is. And that does become important later because, like I mentioned a little bit earlier in the episode, like it can take a while to do a forensic investigation. Even when you have the findings, if there are quite a few impacted individuals in different jurisdictions, you then have to work through your analysis of, does this qualify as a breach in different places? Is there reporting required to government agencies? You have to prepare the notices, you have to prepare the reports. All those things take time. And if you have committed yourself to a very early discovery date before you really had enough information to move the ball on a lot of those subsequent steps, you can put yourself in a tough place from the standpoint of meeting the requisite deadlines.
Yeah. It's interesting because one thing I know we talked a little bit about this at the beginning, but some of the things you said made me think of something that I think is important, and that is, at least I've seen this happen from time to time. I'm not sure if you have, Damon. Maybe you have some thoughts, but there's an assumption sometimes with a situation like this, where because people are thinking that data breaches, notification only really is required when there's social security numbers or credit card numbers, and so when they begin to think about this incident that happened, what this employee took, they're like, well, it's all the business information. There's no social security numbers in that data. And they just proceed down the road of the trade secret issue. And what I think that they don't realize sometimes is that states have over time amended and expanded the definitions of what type of data could trigger a notification obligation. And it could be medical information. It could be, right? So, and it could be non-personal information, right? And so, I don't know, any thoughts on that in terms of how to try to avoid that kind of an issue when it comes up, so that, to your point, you may not have completed the data mining, but how do you make sure that you're not missing or moving too fast forward on the trade secret, which again is important, but that you miss an obligation of a data breach notification that you have to make sure you've addressed?
That's a great point. I do try and flag, in the initial discussion with the client when they come to us with the issue, that PII extends beyond what people traditionally think of. It certainly includes social security numbers and driver's license numbers and financial account information and credit card information, but it also includes stuff like online account credentials or medical information, as you mentioned, in some states, date of birth or digital signature. So I try and put that out there. Sometimes I'll even, I'll mention to the client if they'd like, we can share a list of elements that might be PII. If there's a chance that some of the data might be protected health information under HIPAA, either because the client is a covered entity or they're a business associate, or we're dealing with health plan data and it might be a self-insured plan. I will point out that from a HIPAA perspective, the definition is extremely broad. It can really be just someone's name and the date they went to go for their appointment. Something as seemingly innocuous as that can be PHI. So I think that's a great point. I think there is this inclination to think that if socials or credit card numbers weren't impacted, there's probably nothing further to see there. But that, is definitely no longer the case as these laws keep, it's definitely the trend. These laws keep broadening the definition of a PII. Also for some of our clients that have international operations, the GDPR or other non-US laws may apply, which, similar to HIPAA, have very broad definitions of personal data. So it is important to think about that at the front end, both in terms of understanding the importance of doing that investigation, but also when you're working with, say, a data mining vendor. And some data mining vendors do this all the time. They understand the scope of review that's necessary. But I've worked with quite a few clients that brought in a firm that really is more focused on e-discovery, and maybe they're branching into data mining, and they have these very short lists of what qualifies as PII. And it may be the case that they've already started doing some discovery, and maybe that protocol for doing the discovery needs to be broadened, because the initial review they did, the initial programmatic review, was way narrower in scope than was really appropriate for a potential data breach investigation.
Yeah, no, that makes sense. It definitely is a tough spot for companies, no doubt, but it certainly is important to make sure you have, the right team to consider both the business implications of the trade secrets and how to address that, but also, looking out for potential data breach notification obligations. And maybe that's a good place, Damon, for us to stop, unless you have any other thoughts.
No, I think that's a great place to wrap, Joe. Thanks to everyone for joining us. As always, if you have any thoughts on future episodes, any questions or thoughts about this episode, you can email us at privacy@jacksonlewis.com. And Joe, as always, thanks for joining.
Thanks, Dan.
Thank you for listening to Jackson Lewis's podcast, We Get Privacy for Work. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient. We Get Privacy for Work is available on Apple Podcasts, Libsyn, and YouTube. For more information on our topics, presenters, and other Jackson Lewis resources, visit jacksonlewis.com.